person. I don't have to have one full time. I don't have to guarantee 40 hours a week. I'm not paying all that cost. I have to do it.
Yep.
I do not have to have full-time employee.
I'm pleased that was your question, because I thought when I saw you were asking a follow-up, I thought it might have been, how do I get my $20 back? I can't help you on that one, I'm afraid. Yeah, still working on that. Yeah, good luck. Let me know how you go. Yeah, exactly. As an employer, you can choose whether or not you're engaging your staff. You have every right to decide whether or not you're engaging someone as a casual, a full-time, or a part-time employee. And if you're engaging them as a part-time employee, of course, your obligation is to go and look at the modern award and make sure that what you're doing is compliant with the modern award. And most modern awards will say, again, that you need to have a written agreement with the employee about what average hours they're going to work. So what will be the rough pattern? Maybe it's every Tuesday, Wednesday, and Friday, etc. The written agreement should also say what arrangement will be made to vary those hours. So how much notice do you need to give if you're going to change those shifts around? And again, that's set out usually in detail in your award, how you're meant to do that. And if you've engaged someone as a permanent part-time employee, you of course don't need to be paying them a casual loading. You can just pay them the hourly rate that is provided for by the award. And of course you need to accrue things like paid annual leave, personal carers leave, etc. on a pro rata basis based on the hours they work. Now what happens in most part-time employment relationships is you will need to guarantee a minimum number of hours. So otherwise they are a casual employee. So a true casual is complete fluctuation, varies all the time. A true part-time employment relationship is when you say to someone, I'm engaging you for a minimum of 20 hours and a maximum of 30 hours per week. So there'll be some fluctuation in between them. When you do that though, that means that even if you only engage the person for 10 hours a week, you'll need to pay them for 20, because that's the guarantee of 20 hours. So you can see there some of the ideas that you might then have about how you draft the contracts of employment to ensure that they're compliant.
So I always have an idea what I like to do is put someone in for 3 months. And then we decide to put them full time. That's what
Yeah, you can keep them on a casual employment basis, subject. Remember, casual is distinct and different from part-time employment. You can keep them on those arrangements provided that the modern award permits that you to do exactly that. Yeah. And in that 3-month period that we've talked about, you're really referring to a probationary period. But remember, if yours is a small business, you can dismiss any of your part-time or full-time employees within their first 12 months of employment, as long as it's for a lawful reason, with 1 week's notice.
Okay, let's go on to those national employment standards that you were talking about. So, you can tell us what are they and what do they mean for the employees in the room today?
Right, so the starting point there is that there are these 10 minimum terms and conditions of employment, which I want you to think of as like the foundation of the Fair Work system. So it's the foundation upon which everything else is built. So all these unfair dismissal laws, these modern awards, etc., they all are built on top of these national employment standards. The second thing you need to know is that these national employment standards cannot be bargained away under any circumstances. So even if the employee comes to you and says, listen, I don't actually want 4 weeks of paid annual leave per year. I'm a workaholic. I only want to work. This is not going to happen from Gen X and Y, I don't think. Sorry about my scepticism there, but chances are it's not. Someone else comes to you and says, look, I'm happy to only have 3 weeks of annual leave per year, and in exchange for that other week, you can either pay it out to me, or you can pay me an extra $5 per hour, whatever it is that you agree to. Now, we have this all the time. We have employers who, in good faith, agree to some change with an employee to the NES entitlements. They might even record it in writing, and it's all signed off, and you put it into the employee file. That agreement carries a maximum penalty to you of $33,000. It does not matter that it's entered into in good faith, that you both genuinely want to have that arrangement, that it's better for you, and it might be better for the employee. That is irrelevant under the Fair Work Act. It is an offence to vary any of the NES. So these national employment standards must be provided. The third thing I want you to know about these national employment standards is that they are routinely enforced. So you can't continue along, if you like, disregarding them and thinking it won't really matter. You need to know that the Fair Work Ombudsman, the agency that enforces and investigates employers, enforces the law and investigates employers, they can go back up to 6 years of your employment history. So the longer you leave non-compliance, the potentially bigger the liability will be for your business if you do ever have an employee bring a complaint against you, or you ever get randomly audited by the Fair Work Inspector. So you've got the 10 national employment standards in those documents. Most of them concern things like leave entitlements, for example. The vast majority of them are leave. Most of them will be familiar to you because they carried over, if you like, from the old Workplace Relations Act. So things like annual leave, personal carers leave, which is expands it somewhat to include the right of an employee to care for someone in their household or their immediate family. We have what's called emergency management activity leave for volunteers. That comes under one of the heads there. So you have jury service and emergency management activity leave. That comes under the community services leave type heading. So there are a variation, if you like, on some of these entitlements. Most of them will be familiar. The one national employment standard that I really want you to be aware of, which most employers omit, is this thing called the Fair Work Information Statement. Now, this is a double-sided A4 document. In fact, I don't even know if it is double-sided anymore. It might be in your packs there anyway. It's a very straightforward document, and it sets out what these 10 NES are. But, as an employer, you are legally responsible for providing that document to each and every employee that you have engaged, casual, full-time, part-time or otherwise, since the 1st of January 2010. And what the law says is you only need to give it to the same employee once in each 12-month period. So in other words, if you have a casual and they work for you, and then they go away and then they come back 2 months later, you don't need to give them the statement again. But if they come back 12 months later, you would. And if you've got an employee that you engaged in July of 2010 and they're still with you, you don't need to give it to them again, as long as you gave it to them at the commencement of their employment. And once again, that provision of that statement, which must be given to them on their first day of work or as soon as practicable thereafter, that carries a civil provision, or civil remedy provision, if you like, which means it carries a penalty if you don't do it. So that penalty can be very easily avoided. Make sure you're giving out this document. The vast majority of people that I speak with have never heard of it. And if I can make one more point about the NES, and this should be, I suppose, the clearest reminder to you of the importance of complying with the NES. If we go back to when the Act took effect, so the Fair Work Act was passed and became law on the 1st of July 2009, but the National Employment Standards didn't take legal effect until 6 months later, on the 1st of January 2010. And there's a very important reason that we have this 6-month window between when the law was passed and became law and when you became legally compelled to provide these NES. And the reason is that 6 months was when you were meant to get up to speed and become fully compliant with the NES. And I say that because when we go to the Commission and we argue cases on behalf of our clients, almost every single client says, but I didn't know. I didn't know anything about these NES. No one's ever told me that I'm meant to be providing this document. No one's ever said to me that carer's leave now is part of sick leave and that I have to provide this entitlement. But it doesn't work. That argument of I didn't know doesn't work because you will be told, without a shadow of a doubt, that you've had 6 months to fully come up to speed with that. Now, of course, we can dispute that. We can dispute the effectiveness of the government's campaign about making sure that you're aware of these things. I think the vast majority of employers still have absolutely no idea that these things all took place. And here in New South Wales, we have an added layer of complexity because most of you will be familiar that we used to have a workplace relations system here in New South Wales for private sector businesses that weren't incorporated entities. However, the New South Wales government transferred all of those workplace relations powers to the Commonwealth back in the beginning of the Fair Work Act, which means you all became captured by this legislation. So all of a sudden you have all of these things going on at the same time. It's a lot to keep up with, especially when you're running a small business. When every day you're probably flying between being a cleaner, a social worker, an accountant, all of these things that a small business owner and operator are meant to do, it's hard to also be an employment relations lawyer on top of it. So we're familiar with that, but that idea of I didn't know doesn't work.
So what you're saying is that the matter if the employee is happy and the employer is really happy, and the employee is happy, Fair Work can come in and whack them both or gives the employer for some technicality.
Yeah, I can assure you they'll never whack the employee. It's always a case of the poor employee has been terribly hard done by. I don't mean to sound cynical, it's just based on my experience. But absolutely, and when your interpretation of it is correct. And you might hear, you might see this on the news, etc., or in these debates about workplace relations. You often hear about the re-regulation of the labour market. And that's exactly what we're referring to when you hear that argument. So what we're saying is that in Australia, the freedoms that you used to have as small business owners or operators to reach agreement with your staff about what works best in your business, what is the most flexible and productive arrangements that you can create, that freedom to do that doesn't exist under the Fair Work Act. All of those things have been completely re-regulated by the Fair Work Act. So the NES, the National Employment Standards, are a perfect example of that. You do not have any freedom to negotiate on any of those entitlements, to do so, to vary them and make them less generous, is an offence under the Act. And where you see this most commonly, I suppose, if you go to larger businesses, so let's say you're running a bank, a multi-billion-dollar bank, and you have this CEO that you're paying a few million, probably more than a few $1 million a year to. It's a good job if you can get it. So let's say you're in that job and you're getting $5 million a year, but you don't want 4 weeks of annual leave. So you say, look, I'll take 2 weeks of annual leave, same example again, and in exchange give me an extra $1 million of pay. Well, you're hardly hard done by. You're not going to be worried about how you're going to pay your soaring electricity bill here in New South Wales, but it's still an offence. It's an offence. Even if you've agreed in good faith, even if the employee is the one that comes to you and says, is it okay if instead of this I do that? You agree to it and it's all good at the employee's initiative, it's an offence. There's no penalty to the employee. The penalty exists only to the employee.